We begin today with what threatens to be a full-blown constitutional crisis right here at home, with consequences for every American. Events in Los Angeles could be merely the canary in the coal mine when it comes to which path we take and the very future of our democracy. The Trump administration is heading into the weekend facing protests nationwide from a galvanized opposition and a sharp rebuke written for the history books from a federal judge. That opinion amounts to a legal body blow to Trump's efforts to use the United States military against Americans. It's a ruling currently paused by an appeals court from federal judge Charles Breyer. That order says that Donald Trump can no longer mobilize and command California's National Guard troops over the wishes of California's Governor Gavin Newsom. The judge went even further, though, than what the state of California asked for, which was an order limiting what exactly the troops could do on the streets of Los Angeles. The judge said that Donald Trump's, quote, actions were illegal, both exceeding the scope of his statutory authority and violating the 10th Amendment to the United States Constitution. This is from the ruling. Quote, he must therefore return control of the California National Guard to the governor of the state of California forthwith. The judge went on to say that Donald Trump's order deploying the National Guard, quote, sets a dangerous precedent for future domestic military activity. The citizens of Los Angeles face a greater harm from the continued unlawful militarization of their city, which not only inflames tensions with protesters, threatening increased hostilities and loss of life, but deprives the state for 2 months of its own use of thousands of National Guard members to fight fires, combat fentanyl trade, and perform other critical functions. Here's what California Governor Gavin Newsom had to say about the ruling.
Today was really about a test of democracy. And today we passed the test. We, the people, passed the test. Donald Trump has tested the limits of that and has done so consistently. But today's order makes clear that he is not above or beyond constitutional constraints.
Governor Newsom also took Trump to task, calling him out for suddenly suggesting that he's going to protect farm workers from deportations. Take a listen to Newsom.
This is what he does. He creates a problem, and then he tries to be a hero in his own Marvel movie. Did it on fill in a blank on almost every topic, creates the problem, and then tries to do a make-believe as if you're all perfect little sheep, and you're going to go on with it to be the hero in his own Marvel movie. He initiated those raids. He significantly increased the scale and scope of those raids. That's why he wants the National Guard.
It's where we start today with some of our favorite reporters and friends. In Los Angeles for us once again, my friend and colleague, NBC News correspondent Jacob Soboroff. Also joining us, MSNBC political analyst, host of the Bulwark podcast, Tim Miller, is back as well. And with me at the table, NYU law professor, MSNBC legal analyst, Melissa Murray's here. Melissa, can you just talk to me like I'm not a lawyer, because I'm not, and help me understand the status of this really strong ruling last night?
So Judge Breyer issued this ruling. He had a hearing yesterday in his courtroom. He issued the ruling very quickly. It's a 36-page ruling, a blistering ruling and a blistering indictment of this administration's actions. I will note that it is not necessarily far-ranging. Judge Breyer, who is the younger brother of Justice Stephen Breyer, former member of the United States Supreme Court, said that Donald Trump exceeded his authority in federalizing the National Guard, that he has to do so with the consultation of California's governor, which did not happen here. But as to the deployment of the Marines to Los Angeles, Judge Breyer said that it would be premature to rule on that because those Marines are simply protecting federal buildings right now, which is totally within the scope of federal and presidential authority. So that's on the table for now. What this means right now is this was obviously appealed by the administration to the Ninth Circuit, which is the intermediate appellate court over California. And the Ninth Circuit stayed the ruling until it can conduct a hearing on June 17th, so next Tuesday. So that means for this weekend, when these protests and the No Kings protests and the parade are supposed to happen, we will actually see the National Guard acting under the auspices of presidential authority and not the governor's consultation in Los Angeles. So that can continue to happen, and then the Ninth Circuit will step in. Will it be moot at that point? It really depends on what the president does with regard to protests in other cities and whether he will be nationalizing the National Guard in those other venues, too.
Does the ruling on the substance, which I understand has stayed, impact the legal terrain if Trump decides to deploy National Guard troops to other states with Democratic or Republican governors who don't ask for them?
Well, I think it definitely provides a blueprint for other courts that are considering this issue. I mean, I don't think this is a very difficult question. There are two federal statutes in play here. There is Section 12406, which is the statute that the president has used here. It typically is invoked to nationalize the National Guard in tandem with some aspects of the Insurrection Act. It's only been used without the consultation of a state's governor in, to my knowledge, two circumstances, both involving civil rights. So it was deployed by President Eisenhower in the 1950s to integrate Central High School in Little Rock, Arkansas. It was later used by President Johnson to protect civil rights marchers in Selma, Alabama, without the consultation, obviously, of those states' governors. But otherwise, it's really been used as a kind of collaborative, consultative method with the president consulting with the governor of the state in order to nationalize the state's guard in that way. And Judge Breyer laid all of that out very clearly, and I think if this spreads to other cities, blue cities throughout the country, this is going to be a very potent blueprint for other courts who are examining the same issue.
You said blistering. I mean, in some places it almost reads like a fact check. There is no invasion.
Well, I mean, I think that's a question about the statutory language. So when the president gets to invoke this section of the act and without the consultation of the governor, he has to have to meet certain statutory standards, certain statutory conditions. And one of those is that we are being invaded. We are in open rebellion. And Judge Breyer sort of just stepped through the language of the statute. I mean, this is reading, basically, and said that's not what's happening here. In fact, what is happening here is that we have individuals who are protesting, exercising their First Amendment rights that literally this country was founded on, and it cannot be the case that mere protest amounts to an invasion or a rebellion.